As I understand it from hearing about this morning's oral argument, Justice Kennedy was very interested in the federalism issue as an argument against DOMA, and this is something we have been obsessed with almost at Cato because a number of our adjunct legal scholars and highly prized compatriots have signed a brief arguing that DOMA flunks on federalism. I believe that Ilya and others who are directly with the legal project take a very different view, and I'll ask you about that in a minute. But just to make clear what the stakes are on this, if the brief were followed and it were decided that the federal government had to butt out of domestic relations law in general, and that one consequence of that was that it had to take it as it found it as far as giving benefits, a number of other interesting things would happen, many of which conservatives and libertarians might like, because there would be a new powerful constitutional argument for kicking the federal government out of various other areas that perhaps it shouldn't have gotten into. And indeed, there have been one or two panicky reactions already from left-wing legal commentators who realize what a threat to a massive federal government it would be to have that argument accepted. There also might be a consequence, at least as I would predict, in saying that a future federal government could not restrict the right of states to keep gay marriage illegal, and might perhaps look with a jaundiced eye on the Respect for Marriage Act or enactments of that sort. Am I right in guessing that? Would you like to win on the Federalist grounds if that's the only way to win? I guess I'm asking Evan specifically, but if everyone could react.
Well, I mean, let's be clear. The federalism concerns that are there, I think in this case, are also very deeply intertwined with the equal protection dynamics. So you can't always just treat each strand of the Constitution as separate, particularly when a law is this kind of invidious targeting law that is then inflicted by the federal government, in this case, by the Act of Congress in 1996. So I don't, since you've already introduced me as to your far left, I'm not going to sign on to some broad mandate to sweep away federal power in the name of federalism. But I think in this particular case, it's clear, and I think this was clear from some of the questions, but where they're going to go with this, I think is not clear, and I'm not ready to predict, unlike perhaps Ilya, that Justice Kennedy has settled on federalism versus equal protection. So I don't think it works that way, and I don't think we know that answer yet. But in this case, what happened was, as several justices point out in various ways, was that Congress took an unprecedented, radical step of intruding itself into a domain that everybody agrees, wherever you are on this spectrum, is traditionally, historically, and constitutionally, at least mostly left to the states, and did so in a sweeping, unprecedented way, targeting one group of people to impose a particular policy outcome. That's an entwinement of the two, and it makes it very easy, whether you look at it with federalism concerns or from the strict angle of equal protection, to say what Congress did here doesn't cut it. As Justice Ginsburg pointed out, hardly on the side of the spectrum that you're talking about, is that this wasn't just Congress saying, you know, for tax purposes, we're going to look at this, or for immigration purposes, we're going to look at that. This was Congress saying, for all 1,138 plus federal protections, responsibilities, and incidents of the freedom to marry, we're going to have two classes of marriage. And as she put it, it was marriage and skim milk marriage. That's a problem, whether you look at it with a federalism lens or an equal protection lens.
Which, of course, raises the issue of the federal government just being too broad and affecting so many areas, distinguishing by marriage or not. And even more fundamentally, the role of government in marriage at any level. You know, why should we have to get a license from the government, a piece of paper, recognition, legal recognition? The only reason why we're even debating equal protection and all this is because government is involved. So our first order as libertarians, as classical liberals, would be, have a regime of, common law marriage, hold yourself out as a couple, have whatever church, synagogue, what's the word about for Wiccans, or coven, whoever wants to bless and give you a sacrament, that's fine. But once the government gets involved, there are these other issues. More specifically and technically on the federalism issue, I have a debate with John Adler, a friend of Cato, on the Volokh conspiracy, on Reason magazine's website about the role of federalism in Prop 8. where I say, agreeing mostly with what Evan said, that look, this isn't an issue of whether the federal government has overstepped its bounds, like, say, the Obamacare argument was. This is an issue of whether the Prop 8 case yesterday, a state in having this law, this marriage law or this institution, can lawfully discriminate or treat people differently based on sexual orientation. It's not a slam dunk case by no means. That's not what I'm saying. But I'm saying that's what the issue is. The issue isn't whether federal courts are to be the ones who are making that decision or the executive. By definition, since the ratification of the 14th Amendment in 1868, if you have a state violation of an individual right here on equal protection grounds, I buy that much more strongly than I do a substantive due process argument, then it's for the federal courts to decide that issue. If the states aren't violating anybody's laws, fine. If they are, as I've argued in my brief, as Cato has, then it has to make that ruling. On the DOMA case, that debate has also played out on the Volokh conspiracy. Nicholas Quinn Rosencrantz, who's an adjunct senior fellow here, has debated John Adler and Randy Barnett and others simply by saying, and this came out a little bit at argument today, that of course the federal government has the power to define the terms it uses in its statutes. Justice Alito said, well, what if they didn't use the word marriage? What if they used, domestic couples that are certified or something like that? Well, again, it gets down to the basic issue. It's not about the word marriage that has some sort of magic about it. It's the act of discrimination, of treating different people differently under the law. So that whole federalism inquiry, I think, ultimately has to collapse to equal protection. Now, Justice Kennedy might not agree, and I'm not 100% certain that he's going to vote on federalism grounds, but both Kennedy and Roberts seem to be very attracted to this federalism argument. And I think they might split in how they decide it, and I ultimately don't buy the federalism argument, but I'm not sure. I like the equal protection argument, but for whether on legal or prudential grounds that the court, or at least Kennedy, doesn't want to undermine all state marriage laws by ruling on equal protection grounds in DOMA, we could have this sort of way station on the way to an eventual political resolution in most of the states and the nation as a whole.